Work and
Well, good morning. I was examining the legislative history in KBR, and I do need to address the significance of that history in KBR to return to the point raised by my Lord Justice Coulson. In KBR, the fact that Parliament contemplated that mutual legal assistance could be used to assist the SFO was, we say, one of several factors relevant to determining if the presumption was rebutted. And just to recall what they were, I've already taken you to the factor of the practicality of enforcement. That was on page 1265. There's no need to go back to it. The court's seen it now twice. It's paragraph 29 at letter C, which the Supreme Court said was a particularly relevant consideration when determining whether a provision is extraterritorial scope. Now, that was said by the Supreme Court to provide some support for KBR, so it was weighed in the balance that way. And then in paragraph 31, I showed you the public interest in investigating serious international fraud, and that factor weighed in the balance in favour of the SFO's construction. And in paragraph 32, the court will see on page 1266 at E, in dealing with the purpose of reading, whether it's capable of rebutting the presumption will depend on the provisions, purpose and context of the particular statute. And it also requires consideration of the legislative history and whether Parliament can be taken to have intended that the purpose of the legislation be achieved by other means. But the provisions, purpose and context of the statute steer you towards the factors. And context includes the fact, as we've seen again in this judgment, context includes the fact that a unilateral demand from the SFO deprived the recipient of any recourse to his own courts or authorities of the state where the evidence was located, and without the protections one normally gets from mutual legal assistance. And you see that at the end of paragraph 45. That's what Lord Jones said at the top of page 1271.
He's referring there to, quote, successive acts of Parliament in the first couple of lines. That's the legislative history that he went through.
Indeed.
In order to determine whether or not Parliament intended, as it were, its parallel or bilateral, collateral system to guide the intention of the Act.
Indeed. But my Lord, the point I made yesterday was paragraph 45 is not just summarising the acts of Parliament which came after the Criminal Justice Act. He is relying also on the fact that this system which Parliament developed after the power was created.
Well, you said that yesterday, and that's why I looked to see precisely what value he had attached to this. And it's the first two lines of 45. It's successive acts of Parliament. Some of those obviously post-date, but I think he's inferring that there was a parliamentary policy of developing collateral mechanisms,
Yes.
which started before and continued afterwards.
Absolutely. That's indeed what he describes there. But I rely also I can't see plainly what it says.
Says what it says, yeah.
But I also rely on the fact that he notes that the effect of that was to avoid a construction which gave the SFO the power to make unilateral demands without any recourse to the courts or authorities of the state. Because what he's referring to there, although he refers to the safeguards put in place by the scheme of mutual legal assistance,
Yes.
he's noting that the benefit of that, in contrast with the SFO was proposing, was that otherwise the recipient would face a unilateral demand from the SFO without any recourse to the courts or authorities of the state where the evidence was located. And also he would lack the benefits of the safeguards put in place under mutual legal assistance. So the case is going to turn on this sentence, my Lord, but I do draw attention to it because Lord Jones is making a judgment there about, in my submission, about the vice in the SFO's case, which is that it would be a unilateral demand that would deprive the recipient of recourse to his courts or authorities. But
And you would concentrate upon a lack of ability to appeal to a German court as opposed to a domestic court.
Yes, indeed.
You think that's the recourse to a domestic court is not sufficient?
No, it isn't, because and this is what the Supreme Court, in the earlier passages I took you to, the reason why there's a presumption against extraterritoriality in the first place is that it impinges upon the sovereign rights, not just of states, but of those foreign states' citizens. It deprives them of their right to go to their own courts and argue about the propriety of the request which they face. And the next important factor in sustaining the presumption against extraterritoriality in that case was the fact that the breach of the information notice was a criminal offence. And that was a very important factor in sustaining the presumption against extraterritoriality. And that's the analysis of the Perry judgment, which begins at paragraph 46. And just in terms of how the judgment is structured, the Supreme Court deals with legislative history and then goes on to Perry, in my submission, not simply to summarise a recent relevant judgment, but to take account and to identify the important factor that breach of the notice would be a criminal offence. And in Perry, looking at the analysis,
the warning in paragraph 46 might be thought to be apposite.
Absolutely, and I fully acknowledge the point that was hinted at yesterday by my lord, and I don't deny any of it. I rely on the fact, that's why I took you to the provisions in KBR. I wouldn't be spending so much time, maybe too much time on KBR, if I didn't.
I'm teasing you.
I know. Normally that's my lord the Chancellor.
Yeah.
I'm used to it in this court. But on paragraph 46,
Irresistible.
it is when 46 is there, or maybe just teasing you. Moving on to the next. So the factor in Perry was the criminal sanction, and the final factor, which I'll come to, is the existence of sufficient safeguards in this jurisdiction, where there are safeguards in this jurisdiction to mitigate the exorbitant implication of an extraterritorial power. And we'll see that when we come to Paramount Airways. So those are the factors which I say are relevant to the analysis of whether the presumption is rebutted, not only, and certainly not only in KBR, the question of the availability of mutual legal assistance. So moving on then before we get into Perry, before I leave mutual legal assistance, and to return to what my Lord Justice Green said about the fact that Parliament put in place these structures for the SFO. And we say for the CMA, the structures are also in place, not half as detailed as those, but they're in place to allow it to participate in international systems of mutual legal assistance. Now, there's no sign in the pre-legislative material before the Court of Appeal, before you, that Parliament positively considered mutual legal assistance when creating the power in Section 26. But that route was always open to the CMA. The CMA has never suggested, in this case, that it lacks or lacked the power to enter into systems of mutual legal assistance. And they do have a recent agreement to agree, to which I'll draw the Court's attention now, if I may. And if you keep KBR open, put it to one side, and go to Bundle 5, tab 80. And page 1915 gives you the title. It's the Multilateral Mutual Assistance and Cooperation Framework for Competition Authorities. It's not an agreement itself, it's a framework for agreements. A memorandum of understanding. This is from the 2nd of September 2020. So relevant. It obviously comes much later than the creation of Section 26, but then the Supreme Court in KBR also looked at measures that were produced subsequent to the creation of the power in KBR. And if we look at paragraph or recital 1, we see the parties to this framework: Australian authorities, the Canadian, New Zealand, United Kingdom, and the United States. And then at 4 point, if you go over the page to 1917, there's a reference to a model agreement. And 4.1 tells you that this is a model agreement in Annexure A, and it addresses the following substantive matters referred to in 4.2, including the process of making requests for assistance. And 4.3, over the page, 1921, you see the model agreement. And you go to 1922, the scope of investigative assistance. And 3.3 refers to investigative assistance contemplated by this agreement, includes 3.3b, little 2, obtaining documents, records, or other forms of investigative information. And then over the page, requests for investigative assistance, 4.2, they should be in writing. And then 5 over the page, 1924, because the responding party agrees to respond within 14 days, and the responding party at 5.5 will give updates. The responding party may impose conditions, and the responding party shall execute the request in the manner established with the requesting party to the extent permitted by the responding party's law. So again, consistent with other systems of mutual legal assistance, the responding party is not under a strict obligation to provide the material.
How does this provide guidance on Parliament's intent? This is an agreement between competition authorities.
Yes, and it comes significantly after the creation of the Section 26 power. What it does is show that it is open and must have been open to the CMA at the time of its predecessor, at the time of the creation of Section 26 power, to enter into systems of mutual legal assistance.
But assume that's right. The analysis in KBR is, that's why I drew attention to the first 2 lines of paragraph 45. It was Parliament's strategy, Parliament's policy of creating a collateral or parallel regime, which Lord Lloyd-Jones seemed to think was relevant. So the question is, what does this tell you about Parliament's intent? Because this is a question of interpretation.
Indeed, and that's why I said I can't find anything in the pre-legislative material that indicates that Parliament had in mind the possibility of mutual legal assistance for the CMA. My point is a different one. It is that Parliament can be taken to have known that when it created the Section 26 power, the CMA was able to enter into systems of mutual legal assistance. And there's nothing, the CMA has never suggested in this case that they were barred from doing it in some way, that they lacked the power to enter into agreements like this. It's never been the case. And so I simply submit that this is something which they could have done and Parliament would have known that they had this ability.
Could they do that within the EU? Would it be open to a single member state to enter an agreement with a non-EU state, permitting for mutual cooperation?
At the time, I'm now speculating, at the time of and this point hasn't been taken against me, at the time of the enactment of the Competition Act, in my submission, they, because subject to the principle of equality, I can't see why they couldn't have done it, because there was no overriding, the space hadn't been occupied by EU law at that time.
They had a duty of cooperation as between themselves under the treaty.
Yes. In the implementation of EU law, yes.
And I have a recollection that there were, well, I don't know if there was anything which ever amounted to an MOU between the competition authorities under EU law. I rather doubt it, because we've no doubt have then risked intruding upon the Commission's powers.
But for mutual assistance in relation to the enforcement of domestic competition law, I can't see any reason why the United Kingdom could not have had an agreement like this with Germany at the time of the Competition Act. We're concerned here with the exercise of domestic competition law. I can't see why that would have cut across any powers on the part of the European Commission. And so that refers to the possibility of mutual legal assistance. You have my earlier point that in addition to that, it was always open to CMA and still is to request, as they will request in a formalised system of mutual legal assistance, that the German competition authority exercise its powers to gather information which the CMA needed. It's never been suggested that the German authorities would have refused to do that. That's not part of the CMA's case.
And just for a note, do we know for certain that this was signed? It wasn't just a draft which is somewhere to be found on the internet. There is an actual MOU between those four authorities.
I understand it to have been, the MO, means, you have my point, it isn't, the model agreement isn't a signed agreement. As far as I'm aware, the MOU is agreed. It was agreed in 2020.
Well, perhaps at some point we can have that clarified from the CMA. Not necessarily now, but just so we know at some point. And it's September 2020.
Yes, it was the date that was given for it was the 2nd of September 2020. So I'm moving away now from the alternative routes that were available to CMA to get the information, and coming back to the next important factor, which was the fact that breach of the notice in KBR was a criminal offence, and that's the analysis in Perry. So for this, I'd ask the court to go back to Perry, to the analysis of Perry in KBR on page 1271. Now, my own friend rather skipped over Perry in her analysis of KBR. But as I said earlier, it refers to this very important factor which serves to sustain the presumption against extraterritoriality. And we see at 47 the facts in that case in Perry. Mr. Perry was convicted in Israel of a number of offences of fraud in relation to a pension scheme which he had operated there in Israel. The Serious Organised Crime Agency brought proceedings in England for a civil recovery order, and that sought to deprive him and his family of assets obtained in connection with criminal conduct wherever in the world those assets might be situated. Mr. Perry, his wife and daughters weren't resident or domiciled in the jurisdiction. Information notices were given and at an address in England, but the recipients were known by SOCA to be outside the jurisdiction of the United Kingdom. And if you go to 48 F to G, we see the relevant provision, section 357, empower the judge to make a disclosure order if in relation to part 5, property specified in the application is subject to a civil recovery investigation and the order is sought for the purposes of the investigation. Section 357 sub 4 defines a disclosure order as an order authorising the appropriate officer to give to any person the appropriate officer considers as relevant information. In 49, Lord Lloyd Jones says there are close similarities between the provisions governing a disclosure order under the 2002 Act and a production order under Section 2.3 of the 1987 Act. Both confer a power to make an order in respect of any person, which is why I rely on it by analogy in our case. Over the page, paragraph 50, the Supreme Court in Perry held unanimously that Section 357 of the 2002 Act did not authorise the imposition of a disclosure order on persons out of the jurisdiction. And Lord Phillips dealt with the point in trenchant terms, and I'll read this if I may to the court. The point is a short one. No authority is required under English law for a person to request information, to request information for another person anywhere in the world. Section 357 authorises orders for request information with which the recipient is obliged to comply, subject to penal sanction. And subject to limited exceptions, it is contrary to international law for country A to purport to make criminal conduct in country B committed by persons who are not citizens of country A. Section 357, read at 359, does not simply make prescribed conduct a criminal offence. It confers on the United Kingdom public authority the power to impose on persons positive obligations to provide information subject to criminal sanction in the event of non-compliance. And to confer such authority in respect of persons outside the jurisdiction would be a particularly startling breach of international law. For this reason alone, I consider it implicit that the authority given under Section 357 can only be exercised in respect of persons who are within the jurisdiction. And skipping down to 52, Lord Lloyd-Jones in KBR notes the similarity between 357 of the 2002 Act in Perry and the one he was considering is striking, because furthermore, as Lord Gross accepted in the divisional court in KBR, the public interest considerations under Perry, the Act in Perry, are very similar to those pertaining to the 1987 Act, both in Perry and in KBR. And in this case, the regulator makes a very understandable plea for extraterritorial powers to vindicate an undeniably important public interest, dealing with an international problem of fraud and, in our case, anti-competitive behaviour. And then, what of the notice, the question of notice where an officer of the company is in the UK? Paragraph 54, you see how that was addressed. Now, my own friend criticised the tribunal for querying whether a transient physical presence of an individual in the UK gives the CMA jurisdiction over that person's employer. We saw that in their skeleton also. So we see here what the Supreme Court said about that. Lord Justice Gross observed that the critical consideration in Perry was that persons to whom the notices were given were outside the jurisdiction. It can fairly be said that Perry was not concerned with giving a notice to a person within the jurisdiction. However, to my mind, the fact that in the present case the July notice was served on Miss Akerson, we would call the company secretary, when she was induced to travel to the UK to attend a meeting with the SFO, is not a material distinction. The intended recipient of the notice was KBR Inc., and it remains the case that the SFO is seeking disclosure of documents situated abroad from a company incorporated in the United States with no fixed place of business in the UK, which does not carry on business here. And at page 1274, we see the same important factor of the existence of a criminal offence being considered in relation to the Jimenez case, which begins at paragraph 58, the case where extraterritorial jurisdiction was upheld. And there's a reference there to the nature of the case. It was about the power of HMRC to issue a notice requiring a UK taxpayer resident outside the UK to provide information for the purpose of checking his tax position in the UK. And Lord Justice Patton identified two factors that led him to the conclusion. It wasn't private litigations. It was the prevention of tax evasion, which often is a cross-border aspect. I'm sure the CMA relies on that. The second was the strong policy objectives of conferring effective investigative powers on HMRC. However, says Lord Lloyd-Jones, it was clear that in coming to his conclusion, he was strongly influenced by two further factors, neither of which applies in the present case, nor, in my respectful submission, in this case. The first of these is that the powers conferred were expressly limited for the purpose of checking the taxpayer's tax position, and this meant that the powers were necessarily and only exercisable in relation to someone who has or may be liable for tax in the UK, so has an identifiable relationship with the UK. Secondly, skipping down to F, in Jimenez, non-compliance with the notice was not made a criminal offence, and I rely heavily on this, so the presumption that a statute should not be construed as making conduct abroad a criminal offence had no application. And in my respectful submission, that factor was critical to the Supreme Court's conclusion as the reference to the availability of external mutual legal assistance. And then we come to the next and final factor in KBR, which was safeguards.
Sorry, which was?
Safeguards. The safeguards available in this country to mitigate the exorbitant implications of extraterritorial power. And for that, the Supreme Court examined a series of insolvency cases where the presumption was rebutted. And that was because of the availability of safeguards in this jurisdiction. And we see that in paragraph 62. Referring in particular to a case, Paramount Airways, which is begins at page 1275, paragraph 62. Section 238 of the Insolvency Act provides that where a company subject to the insolvency jurisdiction of the English court has entered into a transaction with any person at an undervalue, the court may make such an order as it thinks fit, and the Court of Appeal held that the court had jurisdiction to make an order against a foreigner resident abroad. And the Vice-Chancellor considered that the expression any person must be left to bear its literal and natural meaning, any person. However, says Lord Jones, an important element to his reasoning was that Parliament was to be taken to have intended that the difficulties such a wide ambit might create would be sufficiently overcome by safeguards built into the statutory scheme. And what were they in Paramount? First, the order was to be made by a court. The order demanding information was to be made by a court which had a sufficiently wide discretion to enable it, if justice so required, to make no order, in particular if the defendant was not sufficiently connected with England for it to be just and proper to make the order against him, despite the foreign element. And secondly, proceedings were not to be brought here in the first place unless the court had first granted leave for the proceedings to be served on the defendants abroad. And one sees the last sentence in paragraph 62, there are no comparable safeguards in the present case. And there are no comparable safeguards in this case. The only safeguards my learned friend referenced were the fact that the CMA will keep confidential the information it obtains from the foreigner, and that the foreigner has the right to come to England and litigate the issuance of the notice. It can be challenged by a judicial review.
There's two further safeguards. One, that you can only exercise the power if there are reasonable grounds.
Yes.
And secondly, the procedural safeguard that you must be given notice identifying the conduct or the subject matter of the investigation. So those are both safeguards.
They are indeed.
I mean, the question is whether Parliament intended that combination to be sufficient protection.
Well, in my submission, no, because each of those safeguards were presumably available in KBR. If one takes them in turn, presumably the SFO would also respect the confidentiality of the information it received. In KBR, the SFO would also be amenable to judicial review if the foreigner unconnected with England wished to challenge the issuance of the notice. Presumably, one has to go back to section 1.3 and the scope of the investigation and request. The information gained could only be used for the purposes of the investigation of which it's gathered. And if one goes back to section 1.3, page 1259, the powers of the director can only be exercisable for the purpose of an investigation under section 1 if it appears to him there are good reason to do so for the purpose of investigating the affairs of any person.
Is the question, I mean, I know
you see where I'm going. Yeah. Again, all of that could be challenged on a rationality basis, just as one would put to me, someone could challenge the issuance of a section 26 notice or the connection between that notice and the section 25 investigation. Yeah. If that was good enough.
You're basically saying that in KBR they weren't good enough, but the question which I think Lord Jones is addressing is whether or not Parliament is deemed to have addressed its mind to the existence of safeguards. So if you have to ask yourself, what were the safeguards, and can you properly infer from those that Parliament intended those to confer a sufficient safeguard for what is otherwise a draconian intervention in somebody's right?
Indeed, and in KBR, from what we see in the judgment, there was no, on this question of safeguards within the United Kingdom, there appeared to be no discussion of whether Parliament had applied its mind to UK safeguards or not. Similarly here, the CMA is not suggesting, there's nothing to say that there are any specific safeguards to mitigate the effect of extraterritoriality in relation to the Competition Act. The only safeguards my friend refers to are the safeguards that exist anywhere, which, in my submission, existed equally in KBR. And so if one is having to infer Parliament's intention, if one is inferring from the safeguards that my friend referred to, that Parliament thought they would be sufficient to mitigate extraterritorial extension, KBR would have been decided the opposite way on that issue at least. That's my point.
Understood.
If I may move on then to Gorbachev and Guriev, the authorities my friend took you to. It's in the same bundle 5, tab 62. Page 1362, please. Paragraph 56. One area which is, and the facts, of course, have been explained to you by my learned friend. One area which has proved particularly sensitive has been attempts by one state to compel evidence or disclosure of documents from persons beyond the jurisdiction of the state. Where a witness is within the jurisdiction, their attendance at trial can be compelled and their documents can be obtained by means of a subpoena, requiring them either to testify or to produce documents, but a subpoena cannot be issued against a witness out of the jurisdiction. If you go on, please, to paragraph 58 over the page. The critical concern in Gorbachev and Guriev was the location of the documents. Neither the Act nor the objections in McKinnon were directed to documents held in the US, even by a British company. Mr. Justice Hoffman, as he was then, stated the applicable principle as being a state should refrain from demanding obedience to its sovereign authority by foreigners in respect to their conduct outside jurisdiction. In 59, the long-standing practice of states has been to deal with the problem of evidence and documents outside their jurisdiction by means of letters of request, whereby a court in which proceedings are taking place will request a court in the jurisdiction where a witness is located to require the witness to answer questions or to produce documents. And that was described by Mr. Justice Cockrell in Nixon Emerdata as the proper, courteous, respectful method of obtaining evidence within a foreign jurisdiction from a foreign party, which is a very sensitive topic in many jurisdictions. Now, in our case, letters of request may not have been available. I'm not suggesting that was a route available to the CMA, but the principle we see here remains good. The proper, as in the proper approach consistent with comity and international law, courteous and respectful method for the CMA to obtain information from a foreigner in a foreign state is to ask the foreign regulator for assistance. And moving on to paragraph 65.
Do they have any powers if they're not in the ECN?
Yes.
The German authorities have the power to require the production of documents from VW and BMW in support of a CMA investigation.
I made that, we don't have the Act in, I made that submission below. We can produce the legislation if the court needs it. It's never been in dispute, as far as I'm aware, that the German Bundeskartellamt can respond to a request from the CMA and order its citizens to produce documents in support of a non-EU investigation. I made that point below, and the CMA said it's not good enough. It's a question of voluntary assistance. We need something that produces something.
It's a discretion on the part of the Bundeskartellamt.
Yes, well, like it is for all of these systems of mutual legal assistance.
Okay, understood. So
you can't oblige, the English authority cannot oblige the foreigner to produce documents. Then McKinnon is considered on page 1364, paragraph 65. And my learned friend took you to this, and if you go over the page, bottom of paragraph 65, again, although there was personal jurisdiction over the bank, Mr. Hoffman held there wasn't subject matter jurisdiction. The content of the subpoena and the order is to require the production by a non-party of documents outside the jurisdiction concerning business which it transacted outside the jurisdiction. In principle and on authority, it seems to me that the court should not, save in exceptional circumstances, impose such a requirement upon a foreigner, and in particular upon a foreign bank. The principle is that a state should refrain from demanding obedience to its sovereign authority by foreigners in respect to their conduct outside the jurisdiction. And you have the point that later on, Mrs. Hoffman treated that as the question for discretion. I think as my Lord Justice Green spotted Justice Mayall's doubts about that. Really, it suggested that jurisdiction didn't exist. There was no question of discretion. But then we see Tucker in paragraph 69. That case was an application under Section 25 of the Bankruptcy Act against a British subject but resident in Belgium. And Section 25 enabled the court to summon any person, again any person, capable of giving information respecting the debtor, his dealings or property, to give evidence or produce documents, while Section 25(6) enabled the court to order any person who, if in England, would be liable to be brought before it under the section to be examined in Scotland, Ireland, or any other place out of England. And it was held, however, that the section did not assert jurisdiction of a person's resident abroad. If we skip down to the beginning of paragraph 71, Lord Justice Dillon referred to the established procedures for obtaining evidence from witnesses abroad by the issue of letters of request or by obtaining evidence on commission. And then 72. 72 is important because we see again the factors which I've been returning again and again. 4 points of significance may be noted. First, the effect of the principle of territoriality was to limit the scope of the section as a matter of jurisdiction, not merely to guide or constrain the exercise of the court's discretion. Second, the background is the absence of any power to issue a subpoena to a person abroad to give evidence or produce documents. This meant it was unlikely to have been Parliament's intention to create such a power. By general words, it's looking at the language itself. Third, the availability of an alternative route to obtain such evidence or documents in a foreign court where the person was to be found, militated against the implication of such a power. And then this, the difficulty of enforcing any order was also a material factor telling against any such implication. And that's the impracticality of enforcement, a key consideration that weighed in the balance in KBR also. And as my learned friend took you, then the analysis follows from paragraph 82 on page 1369. You go to the, I think she read to you paragraph 82, but I'll just go to the 3 lines down. The cases have consistently held that apparently wide and general words enabling documents to be obtained should be interpreted subject to the principle of territoriality. The existence of a letter of request procedure, limitations to which it is subject, would be circumvented if wide-ranging disclosure of documents held by third parties abroad could be too readily obtained by means of an application under Section 34. And that would infringe international comity in ways that would be objectionable to foreign states, just as the UK has objected when other states have sought to obtain documents here without using the letter of request procedure, and even then limited the documents which can be obtained through that procedure. And I return to the point that this is not just about the availability of letter of request procedures or mutual legal assistance. It goes to the propriety of doing otherwise, of imposing obligations on foreigners over foreign documents and subjecting them to criminal sanctions. But the critical factor, of course, in Gorbachev was that the documents were located in England. And we see that at the first sentence of paragraph 83. Finally then, if I could return to Maroof, the case to which my friend went, and as she pointed out to the court, that the facts are very different in that case, but it's useful to see the Supreme Court's latest word in the presumption against extraterritoriality. If you go to 1395, there's a reference to Lord Sumption in the Cox case that my own friend referenced. It's in paragraph 32, about halfway down. And this is to do with the situation in which one seeks to imply extraterritorial effect. He says it's certainly possible, but in most, if not all cases, so he's not saying it's all cases, but in most of them, implied extraterritorial effect will arise only if the terms of the legislation cannot effectually be applied or its purpose cannot effectually be achieved unless it has extraterritorial effect, or legislation gives effect to a policy so significant in the law of the form that Parliament must be assumed to have intended that policy to apply to anyone resorting to an English court regardless of the law would otherwise apply. And as to the first part of that, the question of you don't imply this kind of effect unless the legislation cannot effectually be applied or the purpose achieved without it. Please go to paragraph 41, where Lady Rose returns to the principle, page 1397. Paragraph 41, it's a well-established principle that has been applied for many years with very many enactments. This is the basis for the presumption against extraterritoriality. In the absence of express words, the extraterritorial application of legislation may be implied, but she says it is a high threshold that needs to be overcome. And she agrees that Lord Sumption's comments in Cox should not be read as requiring all cases of implied extraterritorial effect to meet one or both of the conditions. In fairness to Lord Sumption, I don't think he said it was all of them. The point is it's a high threshold.
This is in the case of implied,
Yes,
not express,
not express. And I'll come back to that very shortly when we look at the statute.
which is the difference in KBR in paragraph 28 and 29, where one deals with express and the other deals with implied.
Yes. Now, when we come to the statute, I'll make my submission that we're in the territory here of implied extraterritorial effect, not express, when we look at the statute itself. But in either express or implied extraterritorial effect, one still has to rebut the presumption and look at the factors which are relevant for rebutting the presumption. And then on enforcement, because it was said in Maroof, well, don't worry, because the reality is this power won't be exercised extraterritorially very often, because it'll be very difficult to enforce, it won't cause any inconvenience to anyone. And to that submission, Lady Rose said this, paragraph 46 on page 1398. Despite the flexibility, I reject as a matter of principle the argument that one can rebut the presumption by construing the legislation as having very limited effect when it is applied extraterritorially. It is likely to be no useful purpose served in most cases by imposing the duty with extraterritorial effect. It is less, rather than more likely, that Parliament intended to extend the scope of the duty beyond this jurisdiction. So if a foreigner with no assets in the UK and no connection to this country can disregard the notice with impunity, it is less likely to have been intended by Parliament to extend extraterritorially, to extend to persons in those circumstances. So with those principles in mind, I'd ask the court to go to some of the pre-legislative material in our case, the material that preceded the Competition Act. I'll be brief because my learner friend took you to it. I'll go first to the 1996 consultation document and the first authorities bundle behind tab 19. The first authorities bundle tab 19. It's in tab 19. It's relied on by the CMA. Sorry. At page 216 of the bundle, paragraph 2.48. Now, my learned friend took you to this, but I rely on it for a different point. It deals with jurisdiction. This is shortly before the enactment of the Competition Act. And the government considered the appropriate jurisdictional reach for the UK prohibition. It acknowledged that while the proposed new regime involved a prohibition drawn in terms of effects, that did not mean that the jurisdiction should necessarily depart from the principle of territoriality and follow the so-called effects doctrine, where jurisdiction is claimed on the basis of economic effects felt within a state resulting from conduct outside that state's territory. So the UK wanted in the Competition Act to respect the principle of territoriality to an extent, but the government recognised that the place where an agreement is made is not always the determining factor, and the government believes, therefore, that the prohibition should apply not only to agreements made in the UK, but also to those implemented within the UK. So the concern was that the principle of territoriality had to be respected, but only to that extent. But it was still necessary for the prohibition for agreements made outside the UK that the wrongdoer should be seeking to implement them in the UK. And that respected the principle of territoriality in the substantive prohibition. And the next point, enforcement will be made against businesses established in the UK or against UK assets. My point here is that the CMA's claim under Section 26, its construction, goes much further than what the government envisaged here. Because these notices and enforcement of them is not just contemplated against people who have made agreements which are implemented in the UK. Any person is said by the CMA to include anyone, even if they entered into no agreement producing effects in the UK and did nothing that is going to be implemented in the UK.
That's not quite right, because Section 2.3 is or is intended
Yes.
to be implemented. So implementation was putative or actual.
Correct, my lord. But the CMA's case goes further than saying we can only impose Section 26 notices on those who have implemented or who we suspect of implementing but have not yet implemented.
Yes, there's no equivalent in Section 25 of Section 2.3, but that's because you have to investigate it.
Indeed, but their case is that they have to investigate, but they say that Section 26, any person, includes people against whom there is no conceivable possibility of
And
a
this is
case.
your innocent party.
Absolutely.
Yeah.
The CMA's case is that we must be able to include within any person the victims of anti-competitive conduct abroad, customers, competitors, anyone that we think is information that would be of use to us. And those people, on the CMA's case, don't need to even be accused of doing anything that produces effects in the UK or implementing anything in the UK. The CMA's case does not depend on the possibility that the recipient of the notice will do anything that produces effects in the UK or will even theoretically implement anything in the UK. So their construction section 6 goes much further. I'm asked by my learned junior to show you the guidance as the CMA practice on this, which we have. I'll give it to you. Now, this is the CMA's own document, so it shouldn't be controversial. It's the guidance on the CMA's investigation procedures. Yeah.
Any other copies?
Of course. Yeah. And I didn't understand this to be in dispute, but the part that I'd asked the court to go to is, hang on, sorry, don't worry. Thank you. Yeah. So it's paragraph 6.2. CMA will send out formal information requests, also referred to as Section 26 notices, in writing to obtain information that it considers relates to any matter relevant to the investigation from a range of sources, such as, so this is non-exhaustive, the businesses under investigation, not limited to them, their competitors and customers, the complainants, so obviously the complainants are unlikely to be accused of any wrongdoing, and suppliers. Anyone, and it's not limited to this in CMA's case, they can ask anyone, even wholly innocent people, the victims indeed of the conduct, but under pain of, when it was enacted, criminal sanction, to produce documents held abroad by foreigners based entirely abroad. Sorry? Sorry. No, I said when enacted. I said when enacted criminal sanction.
Right.
So, moving on then please to tab 20, the draft bill explanation. And page 225, my own friend said that Section 26 was enacted to strengthen the powers of enforcement of the CMA and its predecessor. Suggestion being, I think that included the need for extraterritorial powers. But one sees at 8.1 on page 225, the focus of the increased powers of investigation. DGFT can enter premises to inspect and copy documents. The DGFT can use force to enter premises if necessary. Obstructing the DGFT will be a criminal offence, and privilege will apply as it does in the High Court. That was, in my submission, the focus of the increased, Parliament had in mind by way of increased, more muscular investigation powers. There's nothing in the pre-legislative material, which has been scoured by all sides, to suggest that Parliament envisaged extraterritorial application to the Section 26 power. So we move on, please, to the Act currently in force, tab 9 of this bundle. And in section 2 on page 68, we see the definition of the substantive prohibition, and we have accepted throughout that it does have an extraterritorial effect by reference to the word implemented. And even here though, we see, as the government envisaged in the pre-legislative material, a certain degree of respect for the principle of territoriality. Not only must the agreement ultimately be implemented or threaten to be implemented in the United Kingdom for the prohibitions to apply, but there must be, in effect, the agreement must affect trade within the UK and have as its object to reflect the distortion of competition within the UK. So we see jurisdiction and territorial jurisdiction hooks even in section 2.3.
Do you accept that Parliament has addressed itself carefully to the delineation between territorial and extraterritorial effects?
In the substantive prohibition,
In the prohibition.
yes. But as to that, we know that Parliament applied its mind carefully to it, because it's clear that Parliament had the wood pulp judgment of the ECJ in mind when it enacted section 2.3. And we've seen wood pulp, and I won't go back to it. My friend took you to the relevant passage. But what wood pulp makes very clear is that this territorial scope in the substantive prohibition is necessary, because otherwise wrongdoers based abroad, making agreements abroad, which are intended to be implemented in the EU and which distort competition in the EU, would otherwise escape liability entirely without that extended territorial scope. And that would be in respect of their acts and their distortion. And that is coterminous with section 25. Section 25, the power of the CMA to investigate, does, as my Lord Supreme put to me, provide for investigations where implementation has not yet been made out. It's sufficient to show that there may be an effect on trade, there may be distortion within the United Kingdom. But as I said in opening, in our submission, section 26, to which we now turn, is not...
Just on section 25, you accept that's extraterritorial too?
I do. I said section 25 is coterminous with section 2.3.
Yeah.
Because section 25 allows the CMA to investigate to the extent set out in section 2.3. My point is that section 26 is not coterminous with section 25. And I say that because its scope is much broader than the territorial scope of section 25 and section 2.3. And I return to the point I made a moment ago. Section 2.3 and Section 25 contemplate investigating potential wrongdoers who may have or may be about to make agreements which would distort competition within the United Kingdom, agreements which may ultimately be implemented in the United Kingdom. The scope of Section 26 is much broader, and I'm repeating myself, but
The innocent parties.
the innocent parties,
But
indeed.
the fact is that the investigation to which Section 26 is referring has to be an investigation within Section 25, doesn't it? I mean, the Act originally said that in terms. I don't quite know why they deleted that bit, but the fact is that the only investigation which the CMA has power to conduct, to which Section 26 can apply, is an investigation under Section 25.
And that is absolutely true, my lord. But it doesn't follow from that the territorial scope of Section 26 must be coterminous with Section 25. And
When you say that,
well, sorry.
I'm not sure I see the logic of it.
no, I appreciate that, my lord. The point here is, if Section 25 were an umbrella provision that dictated the territorial scope of all of the investigatory powers that flowed from it, Section 27 and Section 28 would have extraterritorial effect also. Section 27 is the power to enter business premises without a warrant. And Section 28, that's on page 79, and Section 28, the power to enter business premises under a warrant. These are also very important investigatory powers provided to CMA for the purposes of the Section 25 investigation. But the CMA accepts that here there isn't the same territorial scope that they claim for Section 26. They say here Parliament was implicitly content for the CMA not to exercise this power outside the United Kingdom. But they say you should infer that Parliament did intend that Section 26 would operate extraterritorially. And there's no...
In other words, first words, for the purposes of an investigation.
In Section
An
26.
investigation has got to be one within the umbrella of Section 25,
Yes,
which we accept is extraterritorial.
yes.
So the purpose of the exercise of the power under Section 26 includes at least an investigation into an purely 100% extraterritorial conduct.
Yes.
So if we're looking at statutory purpose, don't those introductory words point to saying the purpose must be the same as that in Section 25?
The purpose, my lord, is absolutely right. For a wholly
I
extraterritorial...
understand your point about innocent parties. In investigating, you may catch people who are not prohibited by Section 2. And I see that. You know, customers, distributors, competitors, and so on. But the purpose of the investigation is that under Section 25, amongst other things.
So, my lord is absolutely right that this power has to be for the purposes of investigation. The investigation can catch extraterritorial conduct. It doesn't follow that this gives express extraterritorial power to the CMA. The Section 27 power also provides that this power should be exercised in connection with an investigation. It sees that at the end of subsection 1 of Section 27. All of these powers can only be exercised for the purpose of or in connection with an investigation. And so, to the extent that the court considers that there's some express provision for extraterritoriality here, this is not an appropriate hook because it applies equally to something which even the CMA accepts does not give that kind of extraterritorial power. And CMA draws this distinction between Section 26 and Section 27. But there's no suggestion anywhere that Parliament ever made that distinction. Now, the CMA suggests it now to you because arguing that its officers can raid a premises in a foreign country is obviously a bit of a stretch, whereas penalising foreigners for failing to produce documents might seem less egregious. But there are parallels between both invasions of the sovereignty of a foreign state. Compelling a foreign person to produce his documents held in a foreign country disregards whether that is permitted by his law. It disregards any rights he or she might have to challenge that under his own law in his own courts. his own rights under his own laws are set at naught on the CMA's construction. And to the extent that the court again, and my Lord of Screen has been putting this to me a few times, is this express extraterritoriality or not? It is, and I hope my Lords will go back to the statutes where Parliament has provided for extraterritorial jurisdiction. We've seen it in the Bribery Act, we've seen it referred to in KBR itself, and between tabs 1 and 17.
It's interesting, if you do a comparison between the statutory provisions referred to,
Yes.
this is paragraph 28, and if you put them side by side with these provisions, it's not clear they come on the right side of the line for you. These are, I mean, here you've got extraterritoriality built into section 2 on the prohibition and into section 25 on investigation. So you've got a double statement of extraterritoriality, territorially and extraterritoriality. But that's, if you do a side-by-side comparison between the three acts referred to in section 28, it doesn't necessarily help you.
Well, I respectfully disagree, if I may, on two of those points. First of all, too much weight may be placed on for the purposes of investigation in section 26. If that is what's going to give it extraterritorial scope in circumstances where the very same or very similar language cannot work for section 27 and 28, one has to look for more. And in the statutes where Parliament has provided expressly for extraterritorial investigatory powers, it does so with express terms. And one sees that in substantive provisions also. Between tabs 1 and 17, it's set out in very clear express terms. And in fact, when I come to the statute Parliament has currently before it, that's also instructive as to what Parliament does say when it wants to provide extraterritorial investigation powers. But my point comes back to KBR, because in KBR, substantive prohibitions were plainly extraterritorial, that was common ground. And the words any person, similarly, the power could only be used for the purposes of an SFO investigation, investigating those extraterritorial prohibitions. And the Supreme Court said in terms, by reference to Perry and a huge amount of authority, the general words any person cannot be given extraterritorial. That kind of general language of itself cannot ground extraterritorial effect. One must look at the other factors. And those same factors that were in play in KBR are, to varying extents, in play here.
So leaving aside the question of undertaking, you say in section 26, any person means?
Any person in the United Kingdom. As it did in KBR.
The Act uses three different descriptions of status. Sometimes it says any person, sometimes it says any individual, sometimes it says any undertaking. What do you infer from that deliberate choice of different language in relation to investigative powers? It might be said Parliament's been quite careful in working out whether it wishes the power to be exercisable in relation to an individual, which is narrower than an undertaking, a person, which is the broadest of all, and an undertaking, which may or may not be absolutely equivalent with a person, but maybe narrower.
The word person that we see in section 26.1 is deliberately chosen, and in our submission, you see this in our submissions, covers person as defined, the broad definition one sees in the Interpretation Act, but excluding the concept of an undertaking. That's our respondent's notice, and my friend Ms. Abram will be addressing you on that. But I'll need to move on in order to give Ms. Abram time to address the important points that the court will put to my friend Mr. Dimitri. On the injustice that's involved, I mean, one shouldn't just brush aside the innocent party in the construction of section 26. One has you have before you parties that are accused of wrongdoing. So we are not in the same category as innocent persons. But that is vital for the interpretative exercise, because the CMA's interpretation does go that far. And they cannot ask the court to draw some kind of distinction, because that would be judicial legislation, as I said yesterday. So it is critical to consider the category of persons who are accused of no wrongdoing and who will be, on the CMA's construction, subject to these extraterritorial demands and potentially subject to sanctions if they fail to comply. Because that person can be forced to come to England. The idea that we have sufficient safeguards here, the point I made yesterday, this innocent foreigner can be forced in the CMA's construction to come to England to vindicate his rights, a country with which he has no connection, where he's accused of having done nothing wrong, in order to seek to set aside the notice. And that is no safeguard at all. Now, it might be said against me, well, we would never seek to impose sanctions on a person like that. We have discretion whether to pursue someone or not. There's lots of discretion. There's discretion in the court as well. But all of that is too late. That is using a discretionary safety valve to construe the provision, the very thing that the Supreme Court said in KBR shouldn't be done. It's a question of jurisdiction, not of mitigating discretion at a later stage. Now, on the relevance of extraterritoriality to the substantive prohibition, the tribunal itself made a further point that my Lord Justice Green queried. And let's go back to that, if I may. If you just keep the Act open to one side, and I'll take up the judgment. And this is the paragraph 74, sub 4, and tab 15 of the authorities bundle. It's on page, sorry, not the authorities, the core bundle, yep, page 168. In subsection 74, subsection 4, the tribunal addressed this question of whether the investigatory power in 26 was coterminous with the substantive prohibition. And the tribunal said in the final sentence, before we get into the indented bits, the extent to which such considerations can have a material bearing on the construction of section 26 seems to us to be verging on the minimum. Now, ideally, and I'll come to explain in a moment why I think the reasoning here is perhaps as thin as it is, but it is consistent, that sentence is consistent with how the Supreme Court approached the same issue in KBR. One asks in KBR to what extent did the Supreme Court place a lot of weight on the extraterritorial scope of the substantive prohibition and the territorial scope of the investigatory powers. One can only say it didn't have a seriously material bearing on what the Supreme Court ultimately did in its construction. And then this in little 3, Roman 3, at the bottom of section 70, paragraph 74.4. The tribunal says we quite appreciate that broad investigatory powers are, from the point of view of enforcement, desirable, but as in KBR, such desirability doesn't translate easily into a factor to construe a power as having extraterritorial effect. Now, here, all the tribunal is doing is expressing that it is not persuaded that this is the indispensable weapon the CMA says it needs in the battle against foreign cartels. The same argument was had before it, and the tribunal is saying, we are not persuaded that this extraterritorial scope is needed to make your enforcement of competition law effectual. It may be desirable, but they're not persuaded that it is indispensable. And that comes back to the point I made yesterday. 25 years of CMA enforcement, they're very experienced, and I repeat the point I made, that if this was an indispensable element, I made this point below, there would have been evidence to say, without naming names, without getting into the investigations, it's all confidential, but just some evidence as to how often the power is used, how without it they would have been prejudiced. It could have been done at a high level. And all we've had below and here are submissions from counsel. And if this is to be a critical question, and my learned friend places huge emphasis on how toothless and ineffectual things would be left, the provision would be a dead letter, it's not good enough. If it really is so important, we'd expect to see some evidence to support that.
If you're right, what will happen in the future? If you want to set up a cartel operating on the UK, what is the logical thing to do to escape enforcement by the CMA?
Putting to one side the statute, which I'll come back to, I suppose the thing to do would be to go to a country.
From abroad.
Well, no, not from abroad, my lord. You go to a country
Running from Paris and Brussels and Amsterdam, a few hundred miles away.
Not at all, my lord. No, because in those circumstances, the CMA could ask the very reputable and well-established competition authorities for assistance. I was going to suggest, if you want to do something really bad, you go to a country where you would not have...
China and North Korea then?
North Korea would be an ideal place to go if you wanted to avoid an investigation. But there are other disadvantages of living in North Korea and running a business in that country. But Germany has a vigorous competition authority with very extensive powers, and the CMA has never said that the Bundeskartellamt would refuse to help them or lack the power to do so. That's what would happen, and what should have happened here. Turning then to the penalties, going back to the Act. And section, now on penalties. And I'd like to go to the original Act as enacted, section 42 of the original 1998 Act, which is on page 59 of the squad. Section 42, a person is guilty of an offence if he fails to comply with the requirement imposed on him under section 26. Now, the CMA says, well, there isn't a criminal penalty now, and I'll come to that, but the CMA's case is that section 26 had extraterritorial effect from the date of its enactment. They don't suggest that anything changed when the criminal offence was dropped. Their case is that this had extraterritorial effect from the date of enactment. And that runs right into the objections that the Supreme Court raised in KBR and in Perry. If we go then to the Competition Act currently in force, so we're now in tab 9, on page 110, in section 40A, big A. Penalties, failure to comply with requirements. 40A, subsection 1, where the CMA considers that a person has, without reasonable excuse, failed to comply with the requirement imposed on him under section 26, may impose a penalty of such amount as it considers appropriate. And then, that's obviously a civil penalty, but still a sanction, a penal sanction. But if one goes to the offences that still exist, page 113, page 113, section 43. A person is guilty of an offence if, having been required to produce a document under section 26, he intentionally or recklessly destroys or otherwise disposes of it, falsifies it or conceals it, or causes or permits its destruction, disposal, falsification or concealment. So again, for the innocent person, the person accused of no wrongdoing, if that person, a recipient of a notice, is suspected of recklessly disposing of a document sought in the notice, he or she or it is still subject to UK criminal prosecution, regardless of whatever rights or defences he might have in Germany or Vietnam or wherever in the world. That's all irrelevant for the purposes of establishing the offence. And then section 44, false and misleading information. That was referring to documents. Here also an offence if a person provides false or misleading information in a material particular and knows or is reckless as to whether it is false or misleading.
Is that a convenient moment for a break?
Yes, my lord, thank you. Only has to say only 2%.
Yeah, yeah, no, interesting. Yeah. my children gave it to me as birthday present. When I picked up, it was just they really give it to me. They gave me last night, they gave me a silk handkerchief. It's very easy. They just loved it so much. So random. I've been teased quite a lot. I couldn't justify it. Helpful news.
So I'm moving on now, Willow, away from the offences and to CMA's final point on the statutory context, the rules of service. They made a point about the fact that it was possible to serve a penalty notice or a notice under the Competition Act on a foreign company if it had a registered office abroad. My short response to that is that section 48, capital A, sub 9, on which they rely, was enacted in 2013. You see that at the top of page 110. You go to page 110, same tab 9, section 40, capital A, has been in force since 25th of April 2013. But since, when my learned friend took you to the Enterprise Act to show you that service provision, she passed over section 86, and this is to my Lord Justice Green's point about what kind of express language is used. And one goes to tab 11 and the Enterprise Act. One sees, and there are many, many examples like it, that section 86, the kind of language the Parliament does use when it provides for extraterritoriality. You see that in section 86(1). Now this refers to enforcement orders. And it provides that an enforcement order may extend to a person's conduct outside the UK if and only if he fulfills one of the he or she or it fulfills one of the criteria below subsection 1. Now, a Lord might say to me, well, that's enforcement. What's that got to do with the relationship between the substantive prohibition and investigatory powers? My answer would be this. What this demonstrates is that when Parliament legislates for extraterritoriality, it does and has to track through extraterritoriality at each stage, from the substantive provision to the investigatory powers to enforcement. And that's what we see here, and we see it in other statutes also. At each stage where extraterritoriality is intended, it must be stated. It doesn't follow that if it's stated at one level, it must be assumed to follow.
It was made
right
clear
through.
by Lord Jones and KBR that you can have different solutions in different parts of the same statute.
Yes, exactly.
Paragraphs 28 and 29.
Indeed. Moving on from the service point my friend makes, as I said, it's from 2013, but in any event, in view of the extremely broad nature of the power which the CMA claims, and the very onerous implications that it involves for foreigners, including wholly innocent foreigners, even on the CMA's own case, that service provision is not sufficient to demonstrate that Parliament intended Section 26 as a whole to have extraterritorial effect. And I'll move on finally, if I may then, on the question of Parliament's intention to the bill currently before Parliament.
Yeah.
Now, on this, I'm not suggesting this is an aid to the construction of the Section 26 in any formal sense. It's revealing because it shows you what extraterritorial provision would look like had Parliament legislated expressly. And what's really striking, as I said in opening, is that when the government came to legislate to give the CMA extraterritorial investigatory powers, they were less extensive than those which the CMA now claims were granted to them implicitly in 1998. And for that, we have to go to tab 17 of the same authorities bundle, volume 1. Page 186 is the first page of the bill. And the new section 44B is the one that I took you to at the bottom of page 192. Second clause 15 refers to what will be a new section 44A. Extraterritorial application of notices under section 26. This section applies to the exercise of the CMA's power to give a person a notice under section 26. And over the page, the power is exercisable so as to give the notice to a person who is outside the United Kingdom to require the production of a document or information held outside the United Kingdom. And then this is subsection 3. The CMA's power to give a notice under section 26 to a person outside the UK by virtue of subsection 2A is exercisable only if the person's activities are being investigated as part of an investigation under section 25, or the person has a UK connection. The UK connection is defined in subsection 5, UK national, an individual habitually resident here, a body incorporated here, or carrying on business here. This is the kind of language one would expect to see, which respects the principle of territoriality and addresses the problems which the CMA, policy considerations which the CMA raised yesterday.
Well, something, subclause 7 tends to suggest that somebody somewhere seems to have thought there were some existing powers which weren't going to be affected.
Indeed, my lord, and quite rightly it's there. Begs the question, if the CMA is right in its construction of section 26, why this amendment is needed at all. It gives them a broader power.
You have to be slightly careful about that, because then you are using it as an aid to construction, which you said you weren't.
Yes.
Right.
Yes.
And I made a note of that because I thought, well, that's proper,
Yes.
because I don't think it is an aid to construction, but I understand you saying, well, this shows what an extraterritoriality provision looks like.
Yeah.
But if you then say, well, it's in now, so that shows it wasn't in before.
I'm backing off, my lord. I'm backing off. Quite right. But
I'm only doing this to show you that I'm concentrating.
I'm grateful. You're getting on.
It's that well-known principle of interpretation, cake and eat it.
Yes. We don't believe in that in this court. So, but I suppose what I'll try and get away with is to make the same point I made earlier, which is this is how Parliament would legislate if it were doing so extraterritorially, and it's not unusual to see a savour to the extent that anything else is out there. Why would they want to clip the CMA's wings? But my real point is to go to the distinction made between wrongdoers and innocent persons.
Can I come back to a point I've been chuntering in my own mind about, and I know Miss Abrams is desperate to take over from you, but if this case were about a third party based in Germany, it was an innocent third party,
Yes.
that person paying the backside to have to come to the UK, but comes to the UK, instructs lawyers to challenge the exercise of the power, because you have a power, may
Yes.
exercise a section 26 notice. And it might be said that the considerations which go to whether it's extraterritorial will also go to rationality. But you said yesterday it's all about construction. I'm not certain. I mean, this may reflect that they're trying to limit the power so they can't be exercised against third parties. But under the present scheme, a third party who was innocent, who really didn't want to give a document for whatever reason, perhaps because they thought they exposed themselves to a penalty in domestic law, couldn't they just come and challenge it by way of ordinary judicial review?
Of course they could, but if that were good enough, it would have been good enough in KBR, and it would have been good enough in Paramount. Well, it would have been unnecessary in Paramount for the court to refer to the particular.
I understand that. I think the only point is it's not all about the considerations, the policy considerations we're looking about are not only relevant to interpretation. You could have a broad power which has to be exercised rationally and therefore not on the facts of the case extraterritorially, because it would be irrational to do so.
My lord, respectfully, that is not the position which this court has taken, and not the position which the court took in KBR. Lord Justice Mayles in Gorbachev and Guriev made the point that the exercise of such a discretion to do justice to the innocent person is not the right approach, even if it was the one that Mr. Justice Hoffman seemed to take in McKinnon. Discretion is not a basis for sustaining the presumption against extraterritoriality. You have to ask, are the factors satisfied? And one cannot say, oh, don't worry, CMA or the English court will do the right thing. That same argument was made in KBR, it was made in Perry, and it was made in Gorbachev and Guriev, and it was rejected. And so that's why, my lord, it isn't an escape valve, tempting though it might be, on the question of jurisdiction. So what I'm left with then is the CMA's point on the EU practice. And in this interpretive exercise, in my submission, what the EU does is left doing a lot of work for which the EU material is manifestly inadequate. My own friend made very bold assertions about what the EU does, but the CMA has no EU court authority at all for a power they say has been in existence in the EU since 1962. There's an unofficial translation of a Commission decision, but it's useful to see how the Commission itself describes the position. For that, we go to the authorities bundle.
Sorry, which Commission practice in particular? In fact, this is the practice of not enforcing against innocent individuals.
Yes, well, my learned friend says the Commission's practice is to demand documents from any person, anywhere in the world, which belong to the undertaking, which belong to an undertaking, and to threaten and enforce penalties if the person doesn't cough up. The very same power which the CMA claims in this case. But let's see how the Commission describes what it does. And I made the point, I tried to make the point to my Lord Justice Coulson yesterday. What the Commission does in practice is nothing like that, and that's because they are conscious of the constraints on their power pursuant to the principle of territoriality. And if we go to the tab 75 in volume 3, so
With the Act.
no, I'm going to the Commission's own. Oh, you can put the Act away, yes, please. Volume 3, tab 75. Yes. And this is a document produced by the European Commission, 1997. We see it beginning at page 1872. Interesting because, of course, Parliament has taken to have known the EU position when Section 26 was enacted the following year. And we see at page, this is produced by the Director General of Competition of the European Commission, dealing with the Commission, fact-finding, including fact-finding powers under what were then Articles 85 to 86 of the EEC Treaty. And if one goes to page 1875, top of the page, the Commission has only limited powers to obtain information from firms situated outside the EU Under international law, the Commission is not empowered to conduct investigations outside the bounds of its territorial competence if they would impinge on the national sovereignty of a non-member country in whose territory it was purporting to act. Accordingly, on-the-spot inspections are out of the question. In such cases, the Commission can and does send out requests for information, but it cannot impose sanctions if a firm fails to comply. One option open to the Commission is to direct a request for information to a subsidiary of a non-EU firm which is based in the EU. Respecting, in my submission, the very principles of territoriality that the Supreme Court stressed in KBR and Perry. If you go on, please, to tab 79, and this is a further document, but it records a submission made by, again, the European Commission, describing its own practice. We see that at page 1902. It's a submission made by to the OECD in 2018. It's a contribution from the European Commission. And if you go to page 1904, paragraph 16, I remember I took you to this, but I rely on it again for a different purpose. The Commission may send RFIs to undertakings located inside and outside the EEA. But in practice, the Commission has so far refrained from enforcing procedural fines or periodic penalty payments on companies outside the EEA. So to effectively use its investigative powers, the Commission frequently resorts to sending the RFI to an EU subsidiary, a non-EU undertaking, requesting the subsidiary to provide information on behalf of the entire undertaking. So they don't purport to have the power, or they certainly refrain from exercising, forgive me, they refrain from exercising.
They
purport to have
exercise it in accordance with Comity international law.
Precisely, exactly. So but in
What's
substance,
the difference between that and the present case?
this fudge which the Commission uses is not an appropriate basis for this court to make a finding. What this recognises is the principle of territoriality, and we ask that to be vindicated with clarity. It is telling that the Commission purports to have a power which it hasn't exercised, or has exercised, I think, in maybe one case in the 61 years that the Commission has been exercising its competition powers since Regulation 1762. The Commission has investigated and penalised at least hundreds of overseas cartels. And in that time, this is its practice, reflecting the very principles which I've been urging upon the court. Now,
It's an international conundrum, isn't it? You've got cartels that operate from outside of the EU. You've got power, you strictly have powers that you could theoretically use against them, but you're constrained because of Comity international law not to use them. So it's the way you exercise your power.
no, it's about, respectfully, no, it's about construing the power. And as I've been saying now a few times,
I understand. I'm just looking at this, they accept they've got the power, but they say, in practice, looking at paragraph 16, in practice has refrained.
Yes,
We may send RFIs located inside and outside in practice.
yes.
So they say we've got the extraterritorial power, but we recognise the realities of life.
Yes, but it's the realities of life refer to a legal reality. It refers to the legal constraints which operate upon the Commission's powers. And those are the same constraints that operate on the CMA's powers. Those same principles common to international law. This is not a question of convenience and being a decent person. These are legal constraints. The Commission is not slow to use its powers ambitiously. The fact that it has refrained from doing this is telling, and it reflects a legal constraint which operates equally here. And there's not a single example of the Commission penalising a foreigner who's refused to comply. And on that point, you go finally to the text which the CMA itself cites. This is the same bond of authorities, tab 81. It's a textbook describing the EU's antitrust investigations. Page 1932, over the first page. And we see at paragraph 2.48, the Commission has so far abstained from including the threat of sanctions for requests for information addressed to non-EU entities. Now, my own friend and the CMA and their researchers have pulled out maybe one example, which she took you to. That is itself telling in the submission of the 61 years of Commission enforcement. But here we see the learned author saying they haven't even included the threat of sanctions when they address requests for information to non-EU entities. And that seems to be a policy choice driven by the desire to avoid conflicts with other jurisdictions. In the vast majority, what they do is they address requests for information to an EU subsidiary of the non-EU parent company or group because of their approach to the concept of undertaking, on which my friend will address.
Certainly, if this helps or hinders you. I mean, everybody recognises there is the power, but they also recognise the realities of life, that there is a problem. So one way you could have an MOU in saying, well, we're going to issue our extraterritorial notice, will you please help us enforce it? Or you refrain and you try and work around it. But the underlying power is extraterritorial. It's the way in which they apply it in practice, which is the problem.
Well, that runs right back into the discretionary.
This is just what they're saying. This is what they're saying they do. It's the realities of it's the context.
The question is, why do they do it? Now, if they did it out of convenience, if they were afraid of offending somebody for political reasons, and there were evidence to that effect, I'd be in a different territory. That's not what's happening. In my submission, they are confronted by the very same principles of comity international law, which we saw in Woodpop. We saw in Woodpop that those principles apply equally to the EU. And the Commission has their own fudge, but what it reflects in my submission is their legal reality, which is they cannot impose sanctions on foreigners for their foreigners' failure to produce documents in a foreign country.
I agree, but that doesn't tell you anything about the underlying power, which they still say is extraterritorial.
Yes,
All these documents you're showing us in relation to the EU show that they've got the power. They may not exercise it for all sorts of reasons, but they've got the power.
the Commission, that is the fudge. They claim to have a power which they don't exercise. Why don't they? Because if they were challenged, they'd end up in court, and in court, their power would be construed down. It would be construed, as we are seeking to construe Section 26, it would be construed consistently with the principle of territoriality.
Okay, you're absolutely understandable. You're citing the precedent. The precedent hasn't yet happened, but it's precedent.
I asked the court to draw an inference from the 61 years of them not exercising a power they say they have.
Okay.
Sorry to interrupt my learned friend, but just so I don't have to come back to it, would the court mind reading the last sentence, which my learned friend didn't go to, of that paragraph?
I was trying to go to it.
Sorry.
What if the subsidiary of a non-EU?
Yes, so I don't have to come back to
No,
it.
that's the point. That's the undertaking point. I was going to read that, and I'd ask you to read paragraph 2.51 also.
Yeah.
Okay, so the CMA says about this in relation to the Commission's practice. They say that the Commission's practice of demanding information on pain of sanction to the EU-based part of the undertaking, they say, well, that amounts really to the same thing. Really amounts to the same thing as the language they use in their skeleton. But in my submission, especially under ground one, that is not the case at all. Because in one case, like the one that you see here, an order is made against a legal person in the territory. Whereas under ground one, the CMA is claiming a power to demand information from somebody who has nothing to do with the territory at all. No link in its own business, and no link by virtue of any wrongdoing it's accused of having done. So it is not the same thing here. We do not see the same thing here as the CMA claims under ground one of its appeal. So wrapping up, if I may, and coming back to the factors which the court is asked to consider in KBR and in Perry in ascertaining Parliament's intent. The first, penalties. You have my point that non-compliance with the Section 26 notice currently attracts a civil penalty under Section 40A and can lead to criminal offences under Section 43 and 44 of the Competition Act. And I say that strengthens the operation of the presumption against extraterritoriality. I say it's highly unlikely that Parliament would have intended Section 26 to have extraterritorial effect, where that would compel a foreign person to produce documents held abroad on pain of a criminal or other sanction in this jurisdiction. In particular, where this may be a breach of international law or infringe the principles of comity. And that's put in my submission, beyond doubt by the fact that at the time that Section 26 was enacted, mere non-compliance with the Section 26 notice gave rise to criminal offences. And as I said, the CMA's case is that Section 26 had extraterritorial effect from the date of enactment.
Do we apply what Benny would describe as the principle of the speaking legislation, that it evolves over time and you look at it as of today's date rather than through some historical optic?
It's more than a historical optic. It goes to the CMA's rationale for extraterritoriality. Therefore,
But don't we have to look at the Act as it stands today, the date upon which the notice was issued against?
yes, well, but it is an admissible age construction to look at it when it was enacted. The next factor is the impracticality of enforcement, a key factor. At the time that Section 26 was enacted, as I said, the mechanism for enforcement was the criminal offence in Section 42. And the CMA hasn't suggested any way in which that criminal offence could have been enforced against a foreign national outside the UK's jurisdiction. A foreign national with no connection to the UK. CMA has never even approached an explanation for how that could have been enforced. It's completely useless as regards a foreign person wholly outside the UK. And the same must be true of the Section 43 and 44 offences under the current Act. And as regards civil means of enforcement under Section 40A, capital A, the CMA accepts that it can only be enforced realistically against someone with assets in the United Kingdom. Now, as I discussed with my Lord Justice Green yesterday, there is a hint in their skeleton that there might be some kind of, in the future, some international system whereby penal sanctions imposed by regulators might be enforced mutually between different states. That's a single sentence in their skeleton with nothing to support it. And as I said yesterday, it is highly unlikely that any United Kingdom judgment, even one made under the civil procedure rules, could be enforced in that way abroad. Because as Dicey and Morris say, I'll just give you for your note, volume 5, tab 83, page 1977, paragraph 8002, it is well established and almost universal principle that the courts of one country will not enforce the penal and revenue laws of another country. That would be a penal sanction under public law powers. And that's not just a passing difficulty, a little wrinkle in the ski. That's a serious problem with the enforcement of these powers if they were ever to be enforced. The next factor is the legislative history of Section 26 of the Competition Act. And as I said earlier, there is nothing to suggest that the Section 26 power, as opposed to the substantive prohibition, was intended to have extraterritorial effect. And we have, and I'm sure the CMA has too, scoured the records of the House of Commons Steering Committee, the debates in the House of Commons, the explanatory and financial memorandum to the bill research paper, 9853, the House of Lords debates. There is nothing to suggest that the Section 26 powers were intended to operate extraterritorially. And I understand, of course, the point that's put to me, that it follows from the substantive prohibition. But in my respectful submission, it doesn't follow.
No, it follows from Section 25, not Section...
Forgive me, Section 25, I understand.
The principle of symmetry.
Yes, but the symmetry ends there. Because after Section 25, we're into Section 26, 27, 28. They are all powers exercisable pursuant to an investigation under Section 25. But each of them must be construed separately from Section 25 to ask if Parliament intended them to have extraterritorial effect. And each of them are under the umbrella of Section 25.
I mean, I understand the argument, we just have to decide it. I mean, Section 25 has got its own extraterritorial word.
It does, and I don't resolve from that, but
No,
it doesn't follow in my submission that Section 26 has extraterritorial effect. Different provisions have different territorial scope, which says KBR, and there's applying the factors to Section 26. One is a long way from the case law and the kind of express language that the courts found to be sufficient in other cases. And in conclusion on that point, the key submission I suppose I make on Section 25 and 26, by reference to the factors which the Supreme Court tells us to consider is that the investigation under Section 25, the investigation itself doesn't infringe on any other country's national sovereignty. To investigate something itself, to conduct the investigation here in England, doesn't itself infringe anyone's sovereignty. It doesn't prejudice any foreign national or undermine his own rights under his own national law. That is different when one gets into the powers under Section 26 and 27 and 28. That's the distinction. The final point is safeguards in the absence of them. As you saw in KBR, Lord Lloyd-Jones said, of critical importance to the functioning of the international system, of that international system, are the safeguards and protections enacted in the legislation he was considering. And the insolvency cases to which the CMA referred in its skeleton, the courts recognised expressly that safeguards built into the statutory scheme are necessary to overcome the difficulties such a wide ambit may create. And we saw the two key safeguards in Parliament Airways, the fact that power couldn't be exercised unless first the courts had given leave to serve abroad, and there was then a discretion in the court as to whether or not to make the order. Those are all ex ante safeguards, which are not at all the same as a general exercise of discretion or the application of defences once the notice itself has been served. And there's nothing like those safeguards in this case. There's nothing at all to mitigate the extent to which the extraterritorial application of Section 26 would offend, to mitigate the extent to which that would offend international comity and sovereignty. And as I said earlier, the only safeguards they can point to are the very same safeguards that were either expressly or implicitly in play in KBR. And they were not sufficient in KBR, and they aren't sufficient here. Ultimately, that right of appeal to which my friend referred to, and I said this to my Lord Justice Green earlier, is ex post. That's not a prior restraint or a check like the safeguards in Parliament Airways. And it forces the foreigner, even if he's accused of no wrongdoing, to come to England and forces him to litigate here. Now, my own friends might say, well, we'll never impose a sanction on a foreigner, we'll never exercise our power in that way, we have a broad discretion. 2 points to that. First of all, you have my point that question of discretion is not to be used in construing the jurisdictional scope of the power, and the fact that it's unlikely that it will be enforced against a foreigner in that way is a point against the CMA's construction, just as Lady Rose held in the roof. If ultimately the power cannot really be enforced, that suggests that Parliament didn't intend to create it. So unless I can be any further assistance, I'll hand over to
Thank you very much, Mr. Chairman.
I'm very grateful. My Lords, as to Mr Kennelly has indicated, I'm going to address ground two, and I'm going to do that under three heads, if I may. I'm going to start by looking at whether the obligation to produce documents, whether the document request notice was intended to be directed at a specific natural or legal person or persons, as opposed to the whole of a multi-member undertaking. Then second, whether the undertaking concept should be read across from section 59 to section 26. So that's our respondent's notice point. And third, I'm going to look at the indicators against Parliament intending that section 26 should assume extraterritorial effect by means of the undertaking route, the ground two route.
Sorry to interrupt you. Those points, do they presuppose that Mr. Kennelly is either right or wrong on ground one? He says it's natural persons. He says it's persons in the UK. So you say, and that can't include undertakings.
I think if I may say so, my Lord, it works the other way round in the sense that the CMA rely on ground two if they're wrong on ground one. So their primary position is any person anywhere. Yeah. So I'm only relevant if the CMA have lost on ground one and we're still in the game on ground two.
Yep.
So if I may start then with whether Section 26 can apply to the whole of a multi-member undertaking, I want to start by explaining to you why the UK statutory scheme is incompatible with the idea of a Section 26 notice being directed to the whole of a multi-member undertaking. And that first issue raises 4 questions, which I'm going to take in turn. First, why we say that the statutory scheme requires a Section 26 notice to be served on one or more legal or natural persons. And as part of that head, I'll respond to Mr. Dimitri's reliance on the various sections of the Competition Act. Second sub-point is why that distinction matters under the UK statutory scheme. I'm not sure anyone's really explained this to your lordships yet, and it explains why we're here today, so I want to address that. Third, I'd like to address Mr. Dimitri's submissions on the EU regime, which is critically different from the UK rules, and on the 2019 German legislation. And fourth, I'd like to address what the practical consequences would be if the CMA were right on ground 2. So to start, if I may, with why a Section 26 notice has to be directed to one or more legal or natural persons. Yesterday, this was presented to you by the CMA as if it was a matter of convenience or practicality. Well, yes, we may draw a Section 26 notice to the attention of an undertaking via a member of that undertaking, via a legal or natural person, was the CMA's approach. But with respect, that's not a correct reflection of how the legal regime actually works. It's a matter of principle that requires a notice to be directed to one or more legal or natural persons. In the same way, and I'll come to this, you can't sue an undertaking at large. You couldn't just bring a claim against BMW or against Volkswagen. You have to sue, as my Lord Justice Green pointed out yesterday, one or more members of the BMW or Volkswagen undertakings. I'll come to that, but before I do, may I show you where these rules come from and show you how they fit with the structure of the scheme that Section 26 is part of. What the touchstone of where I'm trying to get to is that it's established in case law that where an act has binding legal consequences, it has to be addressed to one or more natural or legal persons to ensure that the addressee can exercise their rights of defence and to enable that act to be enforced. It's not addressed to one or more natural or legal persons. Those boxes can't be ticked. I'm going to show you 4 cases on that. I'm also going to show you the underlying EU legislation. The context is, as Mr. Dimitri mentioned to you yesterday, and as of course your lordships know, the Competition Act regime is based on EU competition law. So we've got Section 60, which, as Mr. Dimitri pointed out, required at the time the Act was introduced that it should be interpreted consistently with EU law unless there was a relevant difference. So I'm going to start by showing you what the EU law position is, and then I'm going to show you the key difference between the EU and the UK regimes. Now, may I start, please, with my 4 cases, and they don't include Crown against L, which Mr. Dimitri showed you yesterday. The proposition that the CMA are citing that case for is that Parliament can deem entities to be persons even if they wouldn't otherwise be persons under the Interpretation Act. And I don't shy away from that as a matter of principle. The question is whether the legislator intended in Section 26 of the Competition Act that an undertaking should count as a person. So may I start with a case that we've provided to the CMA in advance of the hearing this morning, which responds to a point that Mr. Dimitri made yesterday, and it's Arbed. If I may hand up some copies of that.
The 80 authorities weren't enough.
I'm sorry, my lord, I'm sorry. It's always the way. There'll be one more after this, and then I hope they'll be the last.
Well, unless Mr. Dimitri wants to come back with yet more authorities, which he may do.
My lord, well, I was given this particular authority about 2 minutes before the court came in this morning. I will look at it over lunch. I hope that I can respond to it by reference to authorities already in the bundle, but if I can't,
It's not very satisfactory in that respect.
No, I'm very sorry about that, my lord. We should have sent it over last night. We found it last night. We should have sent it over last night, and I'm sorry that we didn't. So Arbed is an appeal from a commission decision finding a cartel in relation to steel. So you see on the first page that the appellant was Arbed SA. And you need to know, in order to understand the judgment, that Arbed SA was the parent company of Trade Arbed, which was alleged to have been the cartel participant in this case. And the context is that the SO, the Statement of Objections, had been sent to Trade Arbed, but the decision had been directed to Arbed SA. And apologies for spoiling the punchline, Arbed SA successfully appealed on the basis they hadn't been sent the SO. And I want to pick the case up, please, on page 10720, paragraph 19, about 4 pages from the end. So the passage on which I rely starts at paragraph 19. In all proceedings, the court says, in which sanctions, especially fines or penalty payments, may be imposed, observance of the rights of the defence is a fundamental principle of community law which must be complied with, even if the proceedings in question are administrative proceedings. So that's the principle, and then how does it apply on these facts? There's a paragraph about what statements of objections do. Then paragraph 21, given its importance, the statement of objections must specify unequivocally the legal person on whom fines may be imposed and be addressed to that person. And then paragraph 22 says it's common ground that didn't happen. Paragraph 23, while it's undisputed that the appellant, so Arbed SA, was aware of the statement of objections addressed to its subsidiary Trade Arbed and of the procedure which had been initiated against that subsidiary, it cannot be concluded from that fact that the appellant's rights of defence were not infringed. And the court goes on, you would have had to have another statement of objections in order to enable proper rights of defence to be exercised. So I take from this, and it's an elementary proposition, that in the context of EU law, rights of defence demand that a particular legal person must be identified who's being held responsible for an infringement. And that's not just in the decision, but it's also in the SO, the previous step, in order to enable those rights of defence. Now I'll take you in a moment to the structure of the relevant EU legislation to show how that maps across onto information requests. There's no scope in this system for the CMA to say that notice to any part of the undertaking is enough to bind every member of it. The second case that I'd like to show you is Akzo Nobel, which is in Authorities Bundle 5, tab 73. So I'd like to pick that up, if I may, on page 1850. So Akzo Nobel is an appeal in the context of the codeine chloride cartel decision. And as my lord knows, it's the classic authority on parent company liability. And the key passage is paragraphs 54 to 59. So I'd like to go through that. It's a case about whether you can hold a parent company liable for an infringement that was directly participated in by a subsidiary. So paragraph 54, the court starts, it must be observed as a preliminary point that community competition law refers to the activities of undertakings. That's the point, of course, that was much emphasised yesterday, and we don't shy away from that. And then 55, explaining what an undertaking is. The court has also stated that the concept of an undertaking in the same context must be understood as designating an economic unit, even if that constitutes several persons. 56, when such an economic entity, so the undertaking, infringes the competition rules, it falls according to the principle of personal responsibility to that entity to answer for the infringement. but 57 is the point that really matters. The infringement of community competition law must be imputed unequivocally to a legal person on whom fines may be imposed, and the statement of objections must be addressed to that person. After the citations, it is also necessary that the statement of objections indicate in which capacity a legal person is called on to answer the allegations. So whether you're a direct participant or a parent company or an implementer. And then 58 is about attribution of liability. And then 59, this is the case, so there can be attribution of liability because in such situation, the parent company and its subsidiary form a single economic unit and therefore form a single undertaking for the case law referred to. Thus, the fact that a parent company and its subsidiary constitutes a single undertaking within the meaning of what was then Article 81 enables the Commission to address a decision imposing fines to the parent company without having to establish the personal involvement of the latter in the infringement. So the only reason that discussion can be relevant is because a decision imposing fines has to be directed to specific persons, not just the undertaking at large. So the last EU law case that I'd like to take your lordships to is Sumal, which is in the following tab 74 of the bundle. And again, you're doubtless aware of this case. It's a preliminary reference to the CJEU from a Spanish court in the context of a damages action relating to the Commission's trucks decision, with which we're all familiar. The defendant to the Spanish claim had said, you can't hold me liable because I'm not an addressee of the decision. It was my parent company that was an addressee of the decision. And so this is about whether you can sue another member of the same undertaking that wasn't itself an addressee of the decision. So if I could pick that up on page 1864, at paragraphs 38 to 39, and again, it's really relevant, so it repays some careful consideration. So at paragraph 38, the court setting out its reasoning as to whether or not the Spanish subsidiary could be sued, given the background, it follows that the concept of undertaking within the meaning of Article 101 cannot have a different scope with regard to the imposition of fines by the Commission under Article 23.2, I'll show you 23.2 in a minute, as compared to actions for damages for infringement of EU competition rules. So undertaking means the same things in both concepts. And then at paragraph 39, clear from the wording of Article 1011 that the authors of the treaties chose to use the concept of an undertaking to designate the perpetrator of an infringement of competition law, rather than other concepts such as those of company or legal person. So the whole of an undertaking can be held liable. Moreover, the European Union legislature used that concept of undertaking in Article 23.2 to define the entity on which fines can be imposed. Then the question is how that actually works in practice, how, as a matter of law, I undersell it by referring to practice, how as a matter of law that is translated into acts that have legal effect. And one can take that point from paragraph 42. When such an economic unit infringes Article 1011, it's for that unit, in accordance with the principle of personal responsibility, to answer for that infringement. In that regard, in order to hold any entity within an economic unit liable, it's necessary to prove that at least one entity belonging to that economic unit has committed an infringement, such that the undertaking constituted by the economic unit is to be treated as having infringed that provision, and that that fact is recorded in a decision of the Commission. Then paragraph 43 goes on to talk about parent company and subsidiary liability. And I'll just pick that up 4 lines from the end, if I may, with "it is therefore." It is therefore the very existence of that economic unit which committed the infringement that decisively determines the liability of one or other of the companies making up that undertaking for the anti-competitive conduct of the latter. And 44 really hammers the point home. On that basis, the concept of an undertaking, and through it that of economic unit, automatically entail the application of joint and several liability amongst the entities of which the economic unit is made up at the time that the infringement was committed. So what the court is saying is liability is delineated, the scope of liability is delineated by the scope of the undertaking as a whole. But you've got to hold entities within the undertaking liable. It's not enough just to talk about the undertaking in the abstract. So the Spanish subsidiary, again spoiling the punchline, but the Spanish subsidiary could be held liable for the infringement, although it wasn't an addressee of the decision. May I just take you to a couple of further paragraphs to show where the reasoning goes from there. So at paragraph 56, the bottom of page 1867, in that regard, it should be recalled that admittedly Article 27.1, and I'll show you that too in a minute, Regulation number 1, 2003, provides that prior to taking a decision establishing an infringement of the rules of competition and imposing a fine, I put in square brackets, on a legal person, because we know from from Axo Nobel and from Arbed that's what's required. The Commission is required to give those who are the subject of the proceedings the opportunity of having their point of view heard. And then skipping on a couple of lines, in that context, the statement of objections is designed to ensure the exercise of the rights of defence by each legal person concerned by the administrative proceedings in relation to the competition rules. And then an important passage. By contrast, if the Commission has no intention of establishing that an infringement was committed by a company, the rights of defence do not require a statement of objections to be sent to that company. The sending of a statement of objections to a given company seeks to ensure that the rights of defence of that company are respected. And then you'll see at paragraph 57 the reference to leading to the imposition of a fine on the legal entities specifically covered. So that shows that decisions, that legal acts in relation to infringement can't just be directed to the undertaking as a whole. They have to be directed to a person within the undertaking. I'd just like to match that case law up with the terms of the modernisation regulation, because once you look at the modernisation regulation, which is Regulation 1, 2003, you see, with respect, there are real difficulties for Ms. Dimitriou's reliance on the analogous bits of the Competition Act 1998. So the modernisation regulation is at Authorities 4, tab 67. And to save me coming back to this bit later, I'm just going to show you a bit I want to refer to later before I show you the bits that are directly relevant to this point. But I'm going to talk about the Commission's power to make information requests shortly. And a key recital to the regulation in that context is recital 23, which is to be found on page 1424. So recital 23 starts, the Commission should be empowered throughout the community to require such information to be supplied as is necessary to detect any agreement, decision or concerted practice. I'll make submissions on how that fits or may not fit with the CMA's position on the scope of the Commission's powers a little bit later. But before I do that, let me focus on the point that I'm making about why requests for information need to be directed to legal persons. And so if we start at page 1434, and that's Article 18. tab 67, page 1434. This is Article 18, requests for information. So my learned friend, Ms. Dimitri, showed you this and said, look, this is couched by reference to undertakings, so it's got to be the case that information requests can be directed to undertakings. But let me show you why it's not quite so simple. And the answer starts at page 1437, and that is Article 23 on fines. You'll remember that I highlighted to you the reference in SUMAL to Article 23.2 on fines, but let's start with Article 23.1. The Commission may by decision impose on undertakings fines not exceeding 1% of their total turnover in the preceding business year, where A, they supply incorrect or misleading information in response to a request made pursuant to Article 17 or Article 18.2. So that's fines for a failure to provide information. And then Article 23.2, which is the provision that was referred to by the court in SUMAL, the Commission may by decision impose fines on undertakings where either intentionally or negligently they infringe the substantive prohibitions of the treaty. Now, both of those provisions are drafted by reference to fines being imposed on undertakings or associations of undertakings, but you have seen, I've shown you, the perfectly clear EU case law that says, in fact, a statement of objection, a decision, a fine have to be imposed on one or more legal persons. The use of the term undertaking in this legislation doesn't mean that a fine can just be imposed on an undertaking at large in the abstract. There's very clear authority to the contrary. I'd like to show you one other provision of this regulation, which is to like effect, and that's Article 27 on page 1440. Before taking decisions, as provided for in articles including 23, the fining regulation that we've just looked at, the Commission shall give the undertakings or associations of undertakings, which are the subjects of the proceedings conducted by the Commission, the opportunity of being heard on the matters to which the Commission has taken objection. So this says the rights of defence must be guaranteed by giving an undertaking the chance to receive an SO in the context of a substantive infringement and the opportunity to be heard on it. But we know that's not the final word. We know that's not the full answer because Arbed, from as long ago as the early 2000s, Akzo Nobel and SUMAL all say, no, these matters have to be directed to one or more legal and natural persons. It's not enough even to direct the decision to another person within the same undertaking. Even if the person who is then fined factually knows about the threatened decision, the threatened fine, that's not good enough. There's an infringement of the rights of defence. So the whole structure of EU law is set up on the basis that these decisions, these fines, these statements of objections have to be directed to legal persons. And now the case law that I've showed you relates to substantive infringement decisions. But as I've taken you through the structure of the modernisation regulation, I've shown you that it's exactly the same for requests for information and fines in that context as it is for substantive infringement decisions and fines in that context. There's no difference between the two. Now, I've shown you the modernisation regulation because those are the references in SUMAL. I am conscious it could be said against me that the modernisation regulation wasn't in force when the Competition Act was enacted, but actually the structure of Regulation 1762 was exactly the same on this point. I'll just give you the references. It's Articles 11, 15 and 19. And that is one of the 80 authorities in the bundle, my lord. So EU law sets out an extremely clear position that is inconsistent with the position that is advanced by the CMA on ground 2. I'd like to show you a UK law case before.
Just in case I'm being a little bit thick, ground 2 makes the point you just made, but it's a person which has a territorial connection to the UK. It's the gist of ground 2. So assuming you're right on these matters, you can't just bring proceedings against the undertaking or serve on the undertaking. There's the added caveat which has a territorial connection in the UK.
Yes, my lord. So I'll come on, if I may, in the third bit of my submissions on ground 2 on why, if I'm wrong about undertaking, there shouldn't be extraterritoriality. Now, of course, if I'm right on this point I'm making to you now, then that question never arises because you can't direct a Section 26 notice on that basis to a person, to a whole undertaking. That never arises, so you don't get the extraterritoriality point. The only route of extraterritoriality in that case would be my learned friend Mr. Kennelly's, or the route that he resists, which is ground 1, any person. So I'm going to show you the UK case, if I may, and that is Crest Nicholson, which is in Authorities Bundle 2, tab 39. So I'm going to pick it up on page 649. It's a very short extract. To give your lordships the context, it was an application for a judicial review of a decision by the CMA's predecessor not to extend or reopen an offer to reduce the penalty. Tab 39, page 649. So just to show I'm not taking it out of context, I'll start on paragraph 31. The obligation not to engage in anti-competitive, it should be, activity, such as cartels in Articles 81 and 82, is imposed primarily on undertakings. The Competition Act 1998 adopts the same approach, and then a reference to Axo Nobel, which I've shown you. And then the important bit for our purposes, the first 3 lines of paragraph 32. While it is to an undertaking that an infringement of competition law is imputed, for the purposes of imposing a financial penalty, it's necessary to address the penalty to a specific legal or natural person within the undertaking. So the law in both the EU and the UK is totally clear that a decision or a fine has to be addressed to a legal or natural person who must be given the right to exercise the rights of defence. And that shows that what was presented to you yesterday as a matter of practicality or convenience is no such thing. It's a much more profound, mandatory legal right. Now, I'd like to show you what the CMA's case is on that, and then I'd like to make some submissions in response to it. So can you have a look to start with at their pleaded case, which in relation to BMW is in the supplementary bundle, tab 2, page 49. So paragraph 58. So the CMA's pleaded position is that while requirements under competition law, including to produce information, can be imposed on undertakings, we disagree, but pleaded cases, it is not in dispute that it is necessary to address the penalty to a specific legal or natural person within the undertaking, albeit the addressee may have attributed to it the conduct of someone else in the undertaking. So that's curious, because the CMA's pleaded position is that a penalty may not be imposed on an undertaking as a whole, on a multi-member undertaking. That was their position below. Now, footnote 27 is also important. It's a reference to a case, and then it says, it is common ground that civil proceedings must be brought against a legal person rather than an undertaking. Now again, that's not their case now. Now, their written case in this court has been that both private damages claims and fining decisions can be made against undertakings as such, even if they're not legal persons. Now, I'm not really taking a pleading point here, because you can well see why the CMA had to change course, had to do an about turn, in order to try and maintain ground 2, because it would be very odd if a Section 26 notice could bind all members of an undertaking, unless the same also applied to fining decisions and private damages claims. We pointed that out below, that major inconsistency in their case, and the CAT agreed. But the difficulty with the CMA's revised position is that it's wrong in law, and I've shown you why that's the case under the EU case law, under the UK case law, but I'm also going to show you why it doesn't fit with the scheme of the Act now.
Just remind us just precisely what the facts were in this case.
Yeah.
Precisely which company was the Section 26 notice
Yeah, so the Section 26 notice, shall we have a look at it actually? That's probably
Tab
the,
4,
yeah, it's tab,
served on the UK subsidiary and on the parent in Germany.
that's, I'm sorry, my lord, that's not quite right. May I just,
Ultimate parent company.
so my lord, if one looks at the notice, if we start by looking at the notice, which I see my lord has already, but it's at supplementary bundle tab 4. So it is addressed to BMW UK Limited and BMW AG, which is the head co. You see that in the indented text, it's said to relate to BMW UK, its ultimate parent company, and any other legal entities within the same undertaking. It was actually only sent to BMW UK, it wasn't sent to anyone at BMW AG. And just while I'm on the facts, my lord, just to complete the exposition of what's happened, which is not controversial, BMW UK received the notice and complied with it, so produced all of the documents within its possession or control. BMW UK is a national subsidiary. It's an indirect subsidiary of BMW AG, and it doesn't have access to the documents, responsive documents held by BMW AG. So the reason we're here is that it said, well, we BMW UK can't give you those documents because we don't have access to them. BMW AG said, well, that's an extraterritorial exercise of power, whether that's by virtue of the any person route or the undertaking route. I think my lord
Is that
is...
a convenient moment to break?
It is, my lord.
Thank you.